The panelists for the third session will address issues relating to strict legal apportionment to causation of disability. The focus for this panel will be the recent decisions of City of Jackson versus WCAB, Rice, and Hikita versus WCAB, Costco. The presenters for this panel are Mr. Jason Marcus and Mr. Richard Jacobsmeyer. Mr. Marcus is a graduate of California State University, Sacramento, and the University of the Pacific McGeorge School of Law. He has been a certified specialist in California workers' compensation since July 2014. Mr. Marcus is currently president of the California Applicants Attorneys Association and a frequent presenter at various legal conferences throughout California. He is also a partner with the firm of Marcus Regalado and Marcus, located in Sacramento, California. Joining Mr. Marcus is Mr. Richard Jacobsmeyer. Mr. Jacobsmeyer attended St. Mary's College, graduating in 1972, and earned his law degree from University of Santa Clara School of Law in 1975, where he graduated cum laude. Mr. Jacobsmeyer is a certified specialist in California workers' compensation and is the managing partner with the law firm of Shaw, Jacobsmeyer, Crane, Claffey and Nix. Our panelists for the next session have just begun. Let's listen in.
The third panel is Apportionment Revisited. I think the emphasis on this panel discussion will be on the City of Jackson versus WCAB Rice decision and the more recent decision of Al-Qaeda. The panelists, I've introduced them before, are Jake Jacobsmeyer. I don't think I have to say anything about Jake. We all have listened to him for years, and we're pleased to have him here. Then we also have Jason Marcus. Of course, he's the current president of CAW. I'll turn it over to them.
So we're going to be talking about, just a second, I'll get my Rice and Akita, covering the City of Jackson case. And so we're going to talk about a little bit of analysis. We're going to have some applicant and defense approaches, tactics, some issues. There's some significant issues when you talk about genetic and hereditary issues in medical legal evaluations and workers' compensation. We're also going to talk then about the Hikita case that talks about permanent disability and apportionment in cases with certain kinds of compensable consequence injuries, and try and create an outline that covers when you're going to be able to get apportionment and perhaps when you're not going to be able to get apportionment. I got the wrong one. I'll use it down. Okay. So obviously our apportionment statute, the one that we deal with almost exclusively, certainly in these cases, 4663, with apportionment of permanent disability based on causation. Rich gave a very good description this morning about apportionment, talking about direct cause, what's directly related to the effects of the industrial injury. Early cases, Escobedo, Yeager, Brody, were all cases that defendants were able to get the courts of appeal and the board to issue decisions interpreting Labor Code Section 4663 that clearly significantly expanded. In fact, in each of these cases, one of the things that the court said was the specific intent of the legislature in adopting the 4663 and 4664 was to result in an expansion of apportionment and not a diminution of apportionment. So it's clearly established as a public policy that they wanted to have apportionment that employers previously could not get was something that they now could get. We still have issues involving causation of injury versus causation of disability, and Rich gave a good explanation of that also, but we do see the board, particularly the board, more so than the Court of Appeals, discussing the difference between causation of injury and causation of disability. There's no apportionment for causation of injury. You can get causation for apportionment of disability, but you can't interchange the two. So just because you might have multiple causes that caused an injury doesn't necessarily mean that you get apportionment to permanent disability, because it still may be that the injury is what caused the disability and that there are no other contributing factors to the disability. That becomes the issue for apportionment. Obviously, substantial evidence is necessary, and one of the things that I constantly am reminding doctors is that the statute says that you need to give an approximate percentage for apportionment. It doesn't have to be precise. It doesn't have to be exact. You can exercise judgment in order to make a decision on how you allocate liability on an apportionment basis. You simply have to give a reasonable estimate of apportionment, and then you have to support that with a discussion as to why you came up with that estimate, where it came from, the how and why of apportionment in those cases.
Jake, is this one on? Yeah, all right. What do you think of a situation where the doctor has said that there is some non-industrial apportionment, but cannot give you that approximate percentage of what the percentage would be of the non-industrial apportionment?
Under Escobedo, Escobedo has a 5-point process for identifying permanent or apportionment for permanent disability. One in the steps that have to do with the decision making on identifying causation of permanent disability, they indicate that the applicant has the initial burden to show how much of the permanent disability is related to the industrial injury. If the medical opinion is there's 2 causes and I can't tell how much is due to one cause, that means they can't tell how much is due to the industrial injury either. And at least from my perspective, and I've argued this before in front of judges, the applicant can't meet their burden. And in reality, what the answer is, the judge doesn't have enough information to make a decision. That's how I think that the way is lined up under Escobedo, that the applicant has that burden, and then once the applicant meets their burden, the burden shifts the defendant to prove apportionment, show that there's a greater level of apportionment available. I'm getting competition, really competition. As a pragmatic matter, what we're seeing at the appeals board is a fairly aggressive approach by the board that in those circumstances.
What do you do?
Yeah.
Okay.
This is all Rich's fault. He picked this place. So,
are you coming to boot us off already?
Wow, that's.
Just so everybody understands in the internet, we're going to have to evacuate everybody quietly. No, I'm kidding. I don't know what this is. It looks like it's a hailstorm. It'll pass shortly, probably.
Before I was so rudely interrupted by, in response to the question from Jason about what happens when you have a doctor who says, I can't decide how much to give to one factor or another, what we're seeing with the appeals board these days is that they're treating that as if the applicant has no burden to show how much of the disability is related to the injury, just that there's a causal connection, and requiring the defendants to prove causation or allocation of apportionment. I think the board's wrong on that. That's the rules we operated under before 899, and those are the rules we're not supposed to operate under anymore. But that's more or less what's happening. So it becomes incumbent upon defense attorneys to cross-examine the doctor and just pin them down as much as you can. The approach I take is say, doctor, there's 2 causes, right? Which one is greater? If you can't say which one is greater, then why aren't they equal? If you could say one of them is greater than the other, how much greater? Is one of them twice as great as the other one is? If it's twice as significant as the other, then why isn't it 2/3, 1/3? All you have to do is give a reasonable estimate. Is it much greater than 2/3? Is it 3/4? And you just pin them down to the point where they say, okay, I can live with that number. I can live with 75-25, 80-20, 90-10. When you get to 99-1, it's really kind of useless. But
we had that situation recently in a case where there was a heart injury that was presumptive and a kidney injury that was secondary to the heart injury, and the physician in the case opined that the kidney condition, which contributed to the person's overall level of disability, was partially industrial and partially non-industrial, but the physician could not give a percentage as to the non-industrial portion, only that he could say some of it was non-industrial. We took that case to trial, and on defendant's motion, the judge correctly told us that under 4663, we actually had to go out and have the QME consult with another physician. I don't know how many of you have ever had that situation occur. I think it's relatively rare, but the judge asked us to do that, so the physician did, called another physician, and that other physician came to the same conclusion, that there was a mixture of industrial and non-industrial causation. That second physician also could not give an approximate percentage for the non-industrial portion, and ultimately there was a finding of an award of disability without apportionment because the defendant didn't carry their burden. I do think it's an interesting question, which we didn't reach in that case, of whether the applicant carried our burden to prove the percentage that was industrial. The judge, I think, implicitly found that we did, but if you look at the language of Escobedo, I think that's something that we look really hard at saying the defendant has the burden on apportionment, but I don't know how strongly enforced it is that the applicant has the burden of proving the industrial percentage.
If you look at Escobedo, the little summary on the WCAB website, they have a listing of the order of that establishes the burden of proof, and there are 5 elements. Number 3 is the element that the applicant has the burden of showing how much of the disability is related to the industrial injury. Number 5 is that the employer has to prove apportionment after the rest of the case has been made. So the applicant's burden goes first. It is not supposed to be, there's no longer in effect a default position that if there's no evidence of apportionment, applicant wins. If you have 2 causes of the injury and the evidence is insufficient for apportionment, my position is the record has to be developed further. The judge does not have a record upon which he can issue a decision, he or she can issue a decision and make a determination regarding permanent disability and apportionment. But that's just me. I have had judges accept that argument too. And I've been ordered to go out and get new AMEs or new QMEs in cases where we've had that kind of a record. We're going to talk about some of the prior cases.
Yeah, so we're just going to, before we get into Rice, talk a little bit about some prior cases that go both ways on apportioning to risk factors. The first one on here, the United Airlines case, Milivojevic, or I'm probably butchering that name. That was a case where the board ultimately found that the injured worker was entitled to an award of disability for a heart condition without apportionment. The doctor in that case had apportioned to what was ultimately determined to be underlying risk factors. In other words, conditions that made the worker more likely to develop the heart condition, but the doctor never opined that that there was any pre-existing pathology, simply that there were risk factors. And some of those risk factors were things like age, gender, family history, race, national origin. The board found that the mere presence of risk factors or statistics that a certain factor makes you more likely than somebody else to develop a condition is not the same as apportionment to causation, and expressly prohibited apportionment to those, again, what were called risk factors. The Vira case, which is an unpublished decision but has some really strong language about the prohibition of apportioning to things like age and gender discrimination, is also an important case to look at. Again, it's unpublished, but I think the idea there is just because somebody has some factor or some history that makes them more susceptible to develop an injury, it does not necessarily follow that means that their disability is then apportionable. And it really goes back to the Escobedo case about the doctor having to draw a distinction between causation of injury versus causation of disability.
But I think it's important to remember in Vira also that the court did say that simply apportioning to a medical condition that may be more associated with one gender versus another is not apportionment to gender. You can apportion to the pathology.
Right.
In that case, the doctor apportioned to the person's age and those factors, and the court said age is not a factor that you can apportion to. You can apportion to the pathology. I suspect in the final analysis, when that case came down, the doctor said what I really meant is I was apportioning to the pathology. The age is something that may affect the pathology, but it's the pathology that I was apportioning the permanent disability to.
Right. So, and then the other one there, the Huber case, it was involving carpal tunnel, and the injured worker had a pre-existing hypothyroidism that had been in place for some 20 years and that the worker was taking medications for. And the evaluator in that case opined that it was the injury, the carpal tunnel injury due to cumulative trauma along with the hypothyroidism that caused the carpal tunnel injury, but the board found that the doctor did not then say that what it determined to be a risk factor was then contributing to the current level of disability, which it distinguished from the carpal tunnel injury itself. Moving on. The Klink case is interesting in that there was an attempt to apportion the worker's disability based on family history. The doctor in that case evaluated the injured worker, took a history that the mother had had some pre-existing complaint of back problems, and then determined that the mother must have necessarily suffered from degenerative disc disease, which in turn meant that the injured worker was predisposed to suffer degenerative disc disease. The court made an interesting comment that they didn't understand how the QME could reach that conclusion about the injured worker's mother without having had reviewed the injured worker's mother's medical records or evaluating the injured worker's mother. And so they disallowed the apportionment there. One of the things Jake and I were talking about as we were looking at these cases is that a lot of this, without trying to sound overly political, tends to vary based on the makeup of the panel you get at the WCAB or which judge is hearing the case. In other words, we've got some cases on the next slide that tend to have similar facts to these cases as far as pre-existing risk factors or genetics or hereditary conditions that the panels on this slide all said were not the proper subject of apportionment, but on some other cases, the board allowed apportionment there. Other ones to look at, the, I'll call it Zidell case. Again, the board rejected apportionment based on a family history, which again they said was risk factors to developing the injury, in that case an aneurysm, but again the doctor in that case did not connect the dots, the how and the why of how those risk factors which made the injured worker more susceptible to developing the aneurysm were actually currently contributing to that worker's level of disability. Give me one sec here. Yeah, so here's what I'm talking about. Let me go back one. In the Zidell case, that's where the board said there was no apportionment, and Commissioner Cuneo dissented and said that he would have allowed apportionment. In the Torres case, we had the majority panel saying that they would allow the apportionment based on genetic conditions that pre-existed the injury, and there Commissioner Sweeney dissented. So again, I don't want to make it a political thing, but there's clearly, at least as these panels were coming down, a divergent set of opinions from the commissioners as to whether something, if a doctor calls it genetics, whether or not it's going to be, whether the apportionment is going to be allowed. Should we get into Rice?
Let's get into Rice.
Yeah, that's what we're here to talk about.
I'm going to go through the Rice case a bit, go through the factual background and the holding. Rice was and some of these facts are really significant. 29-year-old police officer. It's a relatively young man, employed from 2005 to 2009. So he's only been working for between 4 and 5 years as a police officer. He saw his QME on several occasions. The first permanent disability assessment, the doctor allocated 25% each to work activities as a police officer, employment prior to work as a police officer, prior injuries and recreational activities, and personal history, including inherited genetic characteristics. The applicant ultimately underwent surgery, was re-examined by the doctor, and the QME in that case changed the allocation of liability to a 17% to work activities, 17% to employment, to work as prior to being a police officer, 70% to prior injuries and recreational activities, and 51% to personal history, which included inherited genetic characteristics. In arriving at the conclusion on the 51% and also in elevating it from 25 to 51, the doctor cited a number of studies which showed that the existence of degenerative disc disease suggested that the injured worker had a predisposition to development of degenerative disc disease, that it isn't that there's a greater tendency to develop degenerative disc disease. The existence of the degenerative disc disease itself indicated that the injured worker had a tendency or a genetic likelihood to develop inherited degenerative disc disease, because you didn't see degenerative disc disease in the absence of a genetic tendency to develop it. So the doctor said this is somebody who has a genetic condition, citing some of the twin studies and other studies that suggested there was a very strong correlation between the development of degenerative disc disease and an individual's genetic makeup. The WCJ rejected the opinion on apportionment to prior work activities, prior injuries, and the prior recreational activities, but accepted the 51% apportionment to the genetic characteristics. Now, in terms of the employment prior to the work as a police officer, that should be wrapped up in part of the cumulative trauma. That's not separate injury. Remember Mike's idea, when you establish your first cumulative trauma, you take the entire period of employment from day one to the day of the ending date of the injury, and that's all covered by that one. So everything that the applicant did, from his first job at McDonald's to the job working in, as a busboy to his ultimately getting a job as a police officer, is all wrapped up in that cumulative trauma. So there's no reason to allocate to that. The doctor gave absolutely no explanation as to why there was apportionment to the prior injuries or recreational activities, but was deposed on at least 2 occasions on the apportionment to genetic factors, and withheld or stood up very well in terms of the discussion on that. The WCAB reversed, basically saying apportionment to genetics and inherited characteristics is apportionment to immutable characteristics for which the WCAB is impermissible apportionment, is not allowed as a matter of law. Case went up to the Court of Appeals, and the Court of Appeals said, first of all, that apportionment to inherited characteristics is not impermissible as a matter of law. It all depends on whether there's sufficient and substantial evidence to support the opinion on apportionment. They noted that since 899, the apportionment is now allowed to a multiplicity of factors, including factors that could not previously be apportioned to: pre-existing pathology, asymptomatic conditions, even retroactive prophylactic work restrictions. An apportionment that I have yet to see in the 12 years since we passed these statutes. Prohibiting apportionment to immutable factors was to prohibit apportionment to factors that the legislature had clearly said could be considered where there is substantial evidence to support it. And they cite a number of cases where the court and the board in effect had apportioned to genetic types of factors, citing the Acme Steel case where the applicant had a congenital hearing problem, citing the Koss case where the applicant, there was apportionment of 90% to pre-existing degenerative disc disease, which the AME, I think it was an AME in that case, indicated was in part related to the applicant's genetic makeup. It may have been also related to her 350 pounds that she had in her 5'2" stature. So there are probably a lot of causes for that particular case. The board rejected the analysis of the WCAB and said that Dr. Blair cited multiple medical studies. There were no competing medical studies, and that the information that the doctor gave was supported by sufficient analysis. That the doctor even discounted the effect of the studies by saying the studies show approximately 75% of an individual's degenerative disc disease is related to inherited characteristics, but I'm not comfortable going with that much apportionment, and that she discounted it in order to make certain that she wasn't overstating the level of apportionment. And the court noted the doctor could have stuck with the 73 to 75% and said, I'm going to stay with the number that's supported by the literature, and that might very well have been substantial evidence also. They noted that specific genetic testing was not required in order to come to a conclusion that there was a genetic condition because the doctor's testimony was that the actual existence of the degenerative disc disease was the evidence that you needed to show that the applicant had that genetic tendency to develop degenerative disc disease. Getting genetic testing was not necessary. It was the existence of the disease process itself. And they then reversed the case and sent it back to the board and said that you shall find apportionment in accordance with the AME's opinion. They did not address the issues involving the other apportionment, nor did anybody ask them to address those issues. Now, so the things that I think are significant in this case, we'll see how much Jason agrees with me. First of all, it's a CT case, not a specific injury. If this had been a specific injury, I think we might very well have a different analysis, although the existence of the degenerative disc disease would be the same, but it's a CT case. It makes it easier, I think, for the doctor to apportion in that circumstance, particularly if it was not if it was a significant trauma, then I think it would be a more difficult apportionment.
Dr. Blair says as much. There's a quote here in the case where Blair was talking about the lack of research on Mr. Rice's family, and she says, even without researching his family history, the evidence is fairly strong that there is predominantly genetic causation unless there is a clear traumatic injury, which in Mr. Rice's case there was not. So I think Jake's right on that the fact that it was a cumulative injury, not a specific, played a big role, at least in the doctor forming her opinion as to what she was apportioning the causation of the disability to.
I think also the fact there was no significant history of prior trauma, which the doctor could allocate liability or causation to prior trauma, which probably in the long run wouldn't have affected the case because it would still been a pre-existing disability associated with degenerative disc disease. The amount of degenerative disc disease in a 29-year-old was significant. It was significant enough that the applicant had to undergo surgery. Now, you don't ordinarily do surgery for just a neck strain. You have to have enough degenerative disc disease that it causes alteration of the structure to cause radicular symptoms with impingement that requires surgery to unroof that and relieve the radicular complaints. So we're talking about somebody who had significant degenerative disc disease and required surgery. If this was a DRE2, where you could have a neck strain that didn't even require the existence of degenerative disc disease, I think the result here would be completely different. I think it's very difficult to apportion very much to even significant degenerative disc disease with somebody who has a DRE2. That's just basically a muscle strain. And you can get a muscle strain with or without degenerative disc disease. The length of employment, it was less than 5 years of employment as a police officer. That's not a long time to be working as a police officer. He did have a year as I think either a reserve or a volunteer police officer before that, but that's not a full-time position, that's part-time. So we don't have somebody who has 30 years or 40 years in here as a public safety officer, firefighter, or police officer. The applicant's age, 29 years, in relation again to the level of degenerative disc disease, was also, I think, a significant factor. You don't expect to see the level of degenerative disc disease that was shown in this gentleman at age 29. You just don't usually see that. And then the lack of any contrary medical literature. The doctor said, I couldn't find anything else that suggested that the studies that I relied upon were not significant in terms of the causation of degenerative disc disease.
Yeah, the court made much of those studies. I want to read a little bit here about what they said and kind of what they latched onto. They said that Dr. Blair's research indicated that degenerative disc disease in adults may be explained up to 75% by genes alone. And the court goes on to say, in other words, every case of degenerative disc disease in adults is caused in part by genetics or hereditary, and the other part by other factors. And they go on to say it was unnecessary for Dr. Blair to conduct such an analysis. That the applicant attorney argued that because Dr. Blair hadn't done genetic research on this individual, hadn't done any medical research or evaluation of his family, his parents, anybody else, that her opinion was flawed. And the court said, no, it was unnecessary for Dr. Blair to conduct such an analysis because her research indicated that genetics or hereditary was a major factor in all cases of degenerative disc disease. The concern I have there is they seem to adopt the idea that every single case of degenerative disc disease is caused in some part by genetics. That to me is a concerning factor, because then does it open the door that every single person that has degenerative disc disease is automatically going to get some level of apportionment regardless of what the specific doctor's findings are in that case. I'm not sure that's what this case stands for, but the court very much latched onto those studies, and again, the lack of any contrary studies that the doctor was able to find or that any party was able to provide to the doctor.
Yeah, and I agree with Jason. It doesn't mean you're going to get it in every single case. Any case where you get it still has to have substantial evidence. You have to have a medical opinion. The doctor's got to give this conclusion, whether the doctor relies upon genetic testing or genetic factors. I frankly think genetic testing probably isn't going to tell you very much in a lot of these cases. This is all based on scientific literature, really, not based on genetic testing. So it's based on the literature that shows that degenerative disc disease is related to factors. Basically, it's a factor that you can identify with genetically existing. And just to explain, the twin studies took individuals, one of whom may have been a truck driver for 30 years and the other may have been an accountant, but they were identical twins. And when they looked at their spines, what they found was a significant correlation in the amount of degenerative disc disease that the individuals had. And this was done over not just one or two, but a sizable enough study that was considered scientifically valid. So the fact that there's a correlation between people who do heavy work and people who don't, and the correlation that they found was approximately 75%, suggests that the genetic factors that the individuals had was the true cause of the degenerative disc disease, and the other 25% was caused by other factors, primarily environmental, perhaps work-related, perhaps exposure-related to something else, but whatever it was not related to their genetics. So that's the basis for the genetic analysis that Dr. Blair did.
Yes, question.
Where do you think this case puts us with defendants telling genetic testing of work?
We'll get to that.
Okay.
Good question, though.
By the way, at CAW, what I said was, what my clients are advising me is that we now do genetic testing on everyone. And so, as you leave the room, please leave your Coke cans and everything so we can collect them. We have a database we're fixing up, but I don't think that's actually going to happen.
Yeah, so that kind of leads us to, so what do the applicant attorneys in the room here, or defense attorneys that are thinking about how our applicant attorney is going to respond to this? On the one hand, I think had they not used the word genetics in this case and simply said we're apportioning to pre-existing degenerative changes, even asymptomatic changes, pathology, what have you, this would have been simply another run-of-the-mill case that probably was less than a blip on the radar, because that's what we've been dealing with since 899, is apportionment to these asymptomatic pre-existing degenerative changes, where a physician looks at an MRI post-injury and says, well, all of these changes could not have occurred from this injury or since the time of this injury, therefore I'm apportioning some percentage to pre-existing. Disagree or agree with that, I think that's the state of the law right now. And had the medical evidence not gone into genetics in this case, I don't think we'd be sitting here talking about it. But of course, we have gone into genetics, which has everyone a little concerned, or at least on my side of the table has us concerned about what to do. One of the reasons we put those earlier cases in the materials in our discussion today, those panel cases that pre-existed the Rice case, was that I think there's a substantial body of law, perhaps not precedential binding appellate court decisions, but a number of panel decisions, writ denied cases where there has been an attempt to apportion to genetics, and the court has said repeatedly that is simply apportioning to risk factors. Again, I realize that we now have a published appellate court decision, and that supersedes all those board panel decisions. But I still think that there's an argument to be made that just because someone may or may not be genetically predisposed to develop some condition doesn't necessarily mean that that is causative of their disability. Now, in this case, as Jake said, Dr. Blair went through a relatively lengthy explanation of the how and the why, as Escobedo requires, to explain why she believed that those pre-existing changes, which were, in her belief, caused by genetics, were causing and contributing to Mr. Rice's overall level of disability at the time that she evaluated him. But I think that's the analysis that a doctor has to make. Simply to say I'm apportioning to genetics and giving a number, I don't think that's going to be sufficient. If the doctor explains the how and the why, that may very well carry the day. I don't like that, but I think that's, at least as we sit here today, what the law is.
You know, when you look at the series of cases before Rice, many of those opinions by doctors were really just one-line opinions. I'm apportioning 50% to the applicant's inherited tendency to develop arteriosclerotic heart disease based on their family history. That was never really enough to establish a basis for apportionment. So the issue of heredity in that probably didn't even matter. The evidence wasn't there for apportionment. Some of those cases were rejected specifically because of the doctor's discussion of the so-called immutable factors. But most of them were just inadequate discussions of apportionment, or discussions of apportionment that, frankly, I think when you start talking about specifically risk factors as opposed to pathology, are very, very problematic. I don't know that you can never apportion to risk factors, but it is going to be a difficult case, I think, to do it, and I think it's going to take some additional clarification from the appellate courts under the circumstances when you can and can't do it. I think risk factors are still a very problematic issue in terms of causation of permanent disability. What we may also be looking at in cases like this is maybe the issue of challenging causation of injury is really at issue. If heavy work or the work activities don't cause degenerative disc disease, then why are we giving injuries for degenerative disc disease in those circumstances?
Yeah.
A lot of this evidence may, as we go further down the road in the next few years, and as we get additional studies and additional information, we may find out that there really is a very low level of correlation, or at least that maybe the correlation requires some kind of significant activity and not just every kind of mundane job. You know, every file clerk who works for 6 weeks and has back pain, it's not related to their work activity, or they don't have a work injury. That's one of the issues that I think that in the long run may make a difference in this case.
Yeah, I've been seeing that on a semi-regular basis in the last 6 to 12 months. It seems to be primarily at Kaiser, that there are Kaiser physicians who are writing reports for cumulative trauma claims. It's tended to be a lot of carpal tunnel, but also some cases involving degenerative disc disease in the cervical spine or lumbar spine, citing studies and saying that there is no scientific evidence that they're aware of, or that there are new studies showing that cumulative trauma is not the cause of things like carpal tunnel and neck injuries and things like that. Did I catch the doctor's attention in the room here? Yeah.
Well, you bring up a lot of stuff with separating law from the scientific literature and the facts. Seeing pathology on an X-ray doesn't mean you have a disability.
Right.
30% of people out there have protruding discs, and they're asymptomatic and fully functional and have complete motion, but they have the pathology. At the same time, with carpal tunnel, it's been shown that repetitive typing of prolonged typing does not cause the condition. Other activities of repetitive strain do. And I think that's what we're seeing now coming across our desks.
Right, and of course, remember that when we're talking about injury, we don't have to show that the work exposure was the sole cause or even the primary cause of that. And what I've seen lately from some physicians, none of whom are in this room, is that they look at those studies and say, well, the work activity can't cause carpal tunnel, therefore it's non-industrial, but without giving any consideration to an aggravation, whether the work activity aggravated or made worse the underlying condition.
The thing is, a physician, you have to separate the carpal tunnel from the repetitive strain. You can still have an industrial exposure to the repetitive strain, not necessarily necessarily the carpal tunnel.
Yeah. One of the things that I
Way to go, Moses.
I'm gonna, I gotta throw one out at you. Yesterday's news, did you see the story about the astronaut who came back as a twin? They did a DNA on him. He was
yeah
on space for a year.
the twin studies on
DNA was changed 7%.
Yeah.
Here's an industrial exposure changing your genetics.
one of the things
We're setting up the Dr. Blair. Don't worry. We'll take care of it.
One of the things that I found a little frustrating as an applicant attorney in this case is, the applicant attorney raised the argument that Dr. Blair had not conducted any genetic testing on this individual or done any thorough research on this individual's family history. And so I think there's a question as to whether the doctor can say that studies that say that genetics make you more likely to develop this condition are then what is the cause of the disability in this individual's condition without actually doing testing to find out, does this person have whatever genetic makeup was found in those studies that said, these genes equate to this condition. Again, that clearly wasn't enough in this case, but that begs the question is, Jake kind of said tongue-in-cheek, we're going to take your DNA. Well, what happens if I'm in a deposition and a defense attorney, they wouldn't do it in a deposition, I suppose, but makes a motion for production to collect my client's saliva to run a DNA test? Have you taken that approach yet?
No, what I've seen is defense attorneys pull out their handkerchief and grab the water bottle. Take it. No,
doing like the what's the Law and Order thing, right? Where they trick the suspect, right? They do that thing?
That's right.
Okay, yeah.
CSI.
Yeah,
one of those.
CSI. That's what.
No, keep in mind in this, I'm not even certain at this point that we're at a point where we can do DNA testing and necessarily tell all the pieces of information we need to be able to establish that there's some genetic impact or genetic effect, because we know that some people have genes and the genes never become activated. So the genetic factor itself, you may have people who have little or no degenerative disc disease who have the genetic marker for development of it, but it never got activated. It never took effect. So it's more of an issue that they may not show it than the people who actually do show it will have a genetic background. And that was part of the rationale of the doctor, is that the fact that this person has significant degenerative disc disease, and I think the fact that they had it at a very early age, that they didn't have any other factors that indicated it, she said this person is one of those people that must have fall into that category of people that has the genetic makeup. I don't have to do genetic testing to tell that. Their physical exam tells me that they're subject to the kind of genetic impact that causes degenerative disc disease. And I agree with the doctor, it doesn't necessarily mean that you have disability because you have significant degenerative disc disease. The applicant had the degenerative disc disease the day before he became symptomatic. But once he became symptomatic and once he had to undergo surgery, it's pretty undeniable that the pathology played a role in the impairment. That's why I said the difference between a DRE2, where you can have basically muscle strain, muscle problems, but not radicular complaints and not have to have surgery, is really different than once you get into the point where the mechanical effects of your degenerative disc disease or the impact on them is such that now you're requiring surgery to correct the anatomical defects. Now you've got somebody who actually has pathology that is causing symptomatology.
Right. I'm going to skip ahead. We talked about this a little bit about the prior cases. One thing that we talked about in our prep and wanted to mention here was just kind of the procedural discovery issues. Again, one of the things that Dr. Blair relied heavily on, and which the court found persuasive, was the scientific studies that she cited. So does that mean that we all now need to learn how to do scientific research and that we have to start providing those studies to physicians as part of the letters we send before the evaluation, or when we're asking for a supplemental report or at a deposition? There's copyright issues with some of those studies. There's access issues as far as what you might have to pay to access those studies, especially if you're a non-physician. There's the issue of making sure that you're not presenting one study to a physician that says one thing, but presenting that study in a vacuum. Perhaps there's one study that comes to one result, and there's 10 studies that come to some other result. There's the question about making sure those are being interpreted. What is the physician reviewing? Are they reviewing the entire study? Are they reviewing the abstract? What are they allowed to put in their reports to support their opinion? What do they have to put in their reports? Is it enough to say in a footnote, I looked at this study at this page? Do they have to attach the abstract to their report? It's a lot of questions that I think we typically have avoided in the workers' compensation system because, remember, we live by the reasonable medical probability standard, not the scientific standard. But as we're getting into genetics, or as the Rice case suggests that we need to get into genetics, I think it raises just a whole host of questions dealing with scientific studies.
Yeah, I mean, certainly from the standpoint of getting the information to the physician, we do have to pay attention to the rules. Rules require that you serve notice on the other side that you're going to be sending it. It's not part of the medical record, so it's other information. If you're providing it to a QME, if you're providing it to an AME, you have to send it to the applicant attorney at the same time you send it to the doctor. But for a QME, you have to make sure that you have sent it to the applicant attorney in advance, and they can object to it. And then you may have to go down to the board and get the judge, get an order from the judge allowing you to submit the information to the QME, or you may have to then cross-examine the QME with the information at a later date.
What if you're aware of a specific study that was generated from a symposium that referred to multiple twin studies, and you know what the site is, the medical journal article, and you put the site in your letter, which you serve on opposing counsel 20 days before the exam, and you say, doctor, please go look this up. I think it would be enlightening. Is that an appropriate way to address that issue?
Actually, I don't see anything wrong with doing that, because then it's up to the doctor to decide whether that's relevant information or not. So I would say that would probably be permissible under the rules.
Yeah, and I think, Dave, what you said about making sure it's served on opposing counsel, if we go back to the Maxim case and try to decide what's communication versus what is information, I think providing the doctor with a study or even a site to a study likely falls under the category of information, and thus has to be previewed to the other side before you send it to the QME.
I'm not suggesting sending the article.
No.
Letting the doctor know where to find it.
Sure. Doctor?
We would prefer that, because if you send us the studies, we can't bill for the work.
Yeah, Dr. Charles.
I just want to chime in from a surgeon's perspective. The first thing we are told is you do not take a person to surgery based on their x-rays. If everybody that comes to your office and you look at the x-rays, oh, that's bad arthritis, let's go to surgery, you're going to get in a lot of trouble. It's the mechanism of the liability of what the insured owes is based on the mechanism of injury, and then you look at how much impairment is there, what needs to be done to be fixed. So as I'm listening to genetic factors and all the arguments, again, that's why this is a legal medical perspective. But from an orthopedic standpoint, if you, again, look at things like genetics or, again, x-rays to judge whether you're going to take that patient to surgery, I would bet that surgeon is going to be in court most of the time trying to figure out or prove why they did that surgery, et cetera. So.
No, absolutely true. I never suggested the surgery is done because solely of the pathology. It's only when the pathology is altered sufficiently to become symptomatic to cause the radicular symptoms that are non-responsive to conservative care that now you have a condition that has to be fixed. If the applicant didn't have those underlying degenerative disc changes, the probability of you're having to take that applicant to surgery is literally non-existent. You're not going to operate if there's no pathology. So there has to be something to correct. The pathology combined with whatever the effect of the injury is causes the need for surgery. But without that pathology, you're not doing the surgery either. So it's a combination of two. You have to have both. If it was only a matter of pathology, I would have had surgery long ago. I've got a completely collapsed L5-S1, and I've never done anything in my life. I can't figure out where it came from. So then it doesn't bother me. I've never had any back pain. I mean, my spine, there are a lot of orthopedic surgeons would be happy to operate on me. Thank God I'm not going to see those guys. So.
You know, if you want, but you're going to have to pay for that surgery. That's one of the things that the AME QMEs
I'm my own employer. If I want to pay for it, I'll pay for it.
So some other considerations involve both federal and state laws. There's the Genetic Information Non-Discrimination Act of 2008, or GINA, G-I-N-A, which is the federal law. And then California has specifically Government Code Section 11135, which states in relevant part, no person in the state shall, on the basis of sex, race, color, religion, ancestry, national origin, ethnic group identification, age, mental disability, physical disability, medical condition, genetic information, etc., be unlawfully denied full and equal access to the benefits, or is unlawfully subject to any discrimination, to any program or activity that is conducted, operated, or administered by the state or any state agency. Interestingly, in the City of Jackson case, that section was raised by CAW, the applicant's attorneys, as amicus, and in a footnote, the appeals court said that they declined to address that argument because it was not raised by the petitioner, and cited a case which says that the amicus is bound by the issues raised by the parties in chief in the matter. Joe, I know I don't want to put you on the spot, but do you agree with the court's ruling in that effect, or do you think that they could have addressed the Government Code section had they chosen to?
The court can address whatever they want, when they want. They can go out on their own and find their own. Given the nature of the issue, which is the question of consideration of genetic factors in assessing apportionment, we believe that our argument is one the court should have looked at.
I think in this case, because there's no genetic testing, I think the argument would have failed because there wasn't any impact. There never was any genetic testing. There's nothing specific done from that standpoint. So it was really based on the existence of the disease process, and the issue is what caused the disease process. So I think the argument probably would have failed. I agree with Joe. The court can decide to hear whatever they want. I've done amicus work, and I've had the court accept arguments that I made that the applicant attorney had not made,
right,
and make a decision on that basis.
Yeah. There's also potential issues with privacy of family members, right? As you start getting into genetics and family history, that may necessitate questions of the injured worker about their family. What diseases, what illnesses have their parents, brothers, aunts, uncles, etc. suffered from. The injured worker waives a certain amount of medical privacy when they file a claim, but I certainly don't believe there's any waiver of any family member's right to medical privacy just because an injured worker files a claim. And then there's also the question of the accuracy of that information. If you were to ask me what illnesses my parents have, I could probably give you a halfway decent list, but I may not be accurate as to how long they've had those conditions, or whether those conditions are disabling or not, or whether other people in the family, in my extended family, have those conditions. So even if you get that information from an injured worker, I'm not sure you can be certain that that information is actually correct and can be relied upon.
No, I actually think that's true. I remember I was talking with my mom once. I thought my dad had hypertension for years. And I was talking to my mom and mentioned that, and she said, "Your dad never had hypertension." So I had that family history. I thought I had an accurate, at least I could tell a doctor if that my father was hypertensive. At least according to my mother, he never was. Now, it could be that she's wrong or I'm wrong, or it could be we're both wrong. But the fact is that that's all hearsay. So I've always been suspicious about trying to come to a conclusion, particularly in something like spinal problems. I mean, you have no idea that, if they'd gotten a history, his mother had spinal problems, she could have had a spinal tumor. Has nothing to do with the genetic disease. You don't know what the cause is in that circumstance. So, if he had seen his mother's medical records, maybe he could actually testify about it. But I think other than that, it gets to be very problematic.
Yep. Question?
So now that we're going down this rabbit hole, it makes you wonder what the discovery costs are going to be for all of this.
Well, so that I want to get us to Haikita in a moment, so I'm going to skip past some of the stuff about the federal law and the state law. But we may not be going down this rabbit hole. The question he raised is, does this mean that we're going to have exorbitant discovery costs if we have to go down this rabbit hole? There are two pieces of legislation that are currently pending in the California Senate to do away with this case and this whole issue. There is Senate Bill 617 by Senator Bradford, which would effectively say that apportionment to hereditary and genetics shall be excluded as a basis of causation for purposes of determining the apportionment of permanent disability. And then there's a second bill that Senator Bradford has introduced, SB 899. The irony of that bill number is not lost on me. That at its current stage, as it's been introduced, is essentially intent language, but the intent of that statute would be to overturn legislatively the City of Jackson case. It refers to that case as an abhorrent decision that is against the norms and values of the California values and the California judicial system. Whether either or both of those cases go anywhere remains to be seen.
Sounds like he's talked to Art Johnson.
Yeah. There have been attempts in past years to introduce legislation that would prohibit apportionment on the basis of things like gender or other what is often referred to as immutable factors, which the court makes reference to in the City of Jackson case. Some of those have been vetoed in the past, including one that Governor Schwarzenegger vetoed that told us that current law adequately protects injured workers from inappropriate apportionment. We've gotten similar veto messages from Governor Brown saying that the current law prevents apportionment that would amount to discrimination. So perhaps based on what we now have with City of Jackson, we can go back to the governor and say, you told us we didn't need this legislation because current law prevents this kind of apportionment. Well, here it is in a published appellate court decision. So maybe you need to sign this law. We'll see what he does with it.
Just kind of as a final wrap up, I actually agree with Rich that this case is nowhere near as significant as the hoopla around it is. It's essentially, in the final analysis, an apportionment to pre-existing degenerative disc disease. We have different opinions from different doctors in multiple cases as to the cause of pre-existing degenerative disc disease. In many cases, doctors don't give any cause for the pre-existing degenerative disc disease. They just say it's there and therefore I apportion to it. The fact that this doctor actually described the cause for degenerative disc disease added an extra layer of information, but if you'd never had that information, the doctor probably could have come to the same conclusion based simply upon the pre-existing degenerative disc disease and the fact that the applicant was very young, that it was a high level of degenerative disc disease, and that the applicant ultimately underwent surgery. So from that standpoint, this really looks just like a degenerative disc disease apportionment case. What I do think that the case does is it opens up the crack a little bit wider so that the appeals board cannot simply say you apportion to impermissible immutable factors, that argument is now off the table. It doesn't mean you don't have to have substantial evidence. It means you can't reject an opinion which is otherwise substantial evidence by just labeling it impermissible immutable factors. It may have an impact in some cases, but I think from a widespread standpoint, it doesn't really improve our ability to get apportionment. It may improve our ability to make arguments to doctors that a higher level of apportionment in some of these cases is appropriate, because I think anytime you get the Court of Appeals saying that you can get 51% apportionment, it helps to open people's eyes that you're supposed to apportion based on causation and not just give a routine 10% or 20% apportionment on every single case, regardless of the amount of degenerative disc disease, that you have to think about it and tailor it to the actual case and what impact does that condition have on this injured worker.
All right, we're going to move on now to Hikeda. So, quick little bit about the facts of this case. Maureen Hikeda was employed by Costco for roughly 16 years. She was diagnosed with carpal tunnel syndrome and other conditions, including spine injuries, psychiatric conditions. There were some internal medicine conditions that were alleged, and I believe found non-industrial. But ultimately, due to the carpal tunnel syndrome, she underwent carpal tunnel surgery. And subsequent to the carpal tunnel surgery, she was diagnosed with chronic regional pain syndrome, or CRIPS, CRPS. And the physician in that case ultimately opined that she was permanently, totally disabled, 100% disabled post-surgery due to the results of the chronic regional pain syndrome and the loss of function that she had and the chronic pain that she suffered from. The doctor opined that the carpal tunnel syndrome was 90% industrial and 10% non-industrial, but opined that the disability resulting from the chronic regional pain syndrome was solely a result of the surgery, that is the carpal tunnel surgery. Case went to trial. The 90% permanent disability was awarded. The judge found her to be total and then apportioned 10% based on the doctor's opinion that 10% of the carpal tunnel syndrome was non-industrial. Applicant filed a petition for reconsideration. The board granted the reconsideration and remanded the case for a further determination as to whether the other body parts that were alleged, including psych and the disability resulting therefrom, contributed to the applicant's overall level of disability such that 90% was not high enough to accurately reflect that worker's level of disability. Interesting, in that first decision where the board granted recon, they did not overturn the trial judge's finding of 10% non-industrial apportionment, but again, they nonetheless remanded the case in full. Case went back down. They conducted more discovery. They ultimately went to trial again, and I believe at the second trial, they issued a 96% permanent disability. No, excuse me, 98%. Applicant once again appealed once again. The board upheld that decision, and applicant sought a writ at the appeals court. At the appellate court, they ultimately overturned the board's finding on apportionment, finding that applicant was entitled to an award of 100% permanent total disability without apportionment. The logic that they applied was that the 10% apportionment that the doctor had applied for the carpal tunnel syndrome was not apportionment as to the disability, but rather was apportionment to that injury itself. The disability they found, based on the evaluator's opinion, resulted solely from the chronic regional pain syndrome, and the CRPS resulted solely from the surgery, the carpal tunnel surgery. The board looked at some prior cases that found that medical treatment is not subject to apportionment, a theory that we're all very familiar with, and said that on the same basis, if disability results as the result of medical treatment that is rendered to cure relief from the effects of the injury, even if that underlying injury is not fully industrial, that the resulting disability is fully industrial, that is, that the worker is entitled to an award of disability without apportionment for the disability that flows from that, the compensable consequence, the result of the surgery. The defendant in the case made a couple of interesting arguments. First, they raised somewhat late in the game the argument that applicant had failed to timely appeal from the first decision, the first board grant of recon, where they did not disturb the initial 10% apportionment finding. The court considered that argument, the appeals court considered the argument, but found that because that first board decision had remanded the case in full, that there hadn't been any final decision, and that from a looking at it kind of from a judicial economy or even just a common sense standpoint, it didn't make sense to make the injured worker or any party take an appeal from that decision, again, the first decision where the board remanded the case, to take that up to the appeals court when there were still other issues that needed to be decided. They said it was appropriate for the injured worker to wait until there was a final decision of the board on all issues before taking that up on appeal. And then, of course, they argued that there needed to be apportionment under 4663, and the appeals court, again, said that apportionment was not appropriate in that case. There's been a lot of talk about, what HIKITA means going forward. Does it suddenly mean that any disability that is a compensable consequence is going to not be subject to apportionment? And as I yelled out earlier in the morning, I don't think that's the case. I actually agree with what Rich said, how he framed it, that if the compensable consequence is a separate condition or a separate injury from the underlying industrial injury, that's likely where Hikita is going to apply. If the compensable consequence is simply a worsening or a continuation of the initial injury or whatever condition was treated, I'm not sure that Hikita is going to apply. As I said earlier, I think that approaching this case with some level of moderation is important. If you have a case similar to Hikita where a person has carpal tunnel syndrome or some other condition, they have surgery, and either there's a complication from that surgery that results in a new condition, or they have a poor result from the surgery and they develop some new condition, I think that's on all fours with Hikita. What's less clear to me is the situation where you have somebody with a knee injury with pre-existing degenerative arthritis in the knee. They undergo a total knee replacement, and now the disability is based solely on the diagnosis-based estimate in the AMA guides for a good, fair, or poor result from the knee replacement. I don't know if that's something that Hikita is going to prevent apportionment to if the doctor would otherwise apportion a percentage of the disability to those pre-existing degenerative changes which pre-existed the surgery.
And that's one of the issues that actually was raised in the case. They cite the Steinkamp case, which is a board panel decision where the board issued, this is quite a few years ago, right after 899 passed, where the applicant did undergo a total knee replacement, and the argument was whether there was apportionment to the pre-existing degenerative changes. You don't typically do a knee injury or knee replacement unless there's severe osteoarthritis, multi-compartment degenerative changes. You can get those post-traumatically, you can have a severe trauma, but when you're looking at most cases, you have somebody who has significant pre-existing condition. And so the question is, do you apportion to it? In Steinkamp, what the board said was, well, once you do the surgery, there is no more pre-existing condition, and therefore the knee replacement is an independent factor of disability that's related only to the injury because the injury caused the need for surgery. The board itself has basically rejected the Steinkamp analysis in about a half dozen cases that followed it. So from the standpoint of the board, Steinkamp was not the case law that existed. My argument would be is that the surgery in a case like Steinkamp is not the result is not caused by the surgery, the result is caused by the injury, and therefore the apportionment would apply. This is the natural result of the treatment. It's not an aberration, it's not a new condition, it's not an unexpected result, it's the expected result, it's the anticipated result from the surgery. A more difficult question, I think, actually gets somebody who takes medication as a result of some orthopedic problem and develops hypertension. Now, they may have been hypertensive before, and now they have more significant hypertension, and the medical opinion is this hypertension has now been aggravated or increased as a result of the medication. Do we get apportionment in that circumstance? The causation is related to the medical treatment effective from the injury. I think the holding in this case is because the medical treatment is required, the medical treatment is unapportioned, the consequences of the medical treatment are going to be unapportioned also, and that's sort of the rationale of the court. They cite Granato, which says that apportionment or medical treatment is not apportioned. They cite Fitzpatrick that says the compensable consequences or the results of medical treatment, including misadventure from medical treatment, are compensable consequence and reimbursable by the employer. Those are the authorities that they really cite in this case, and then say our conclusion is that means that the permanent disability when caused by the injury is also unapportioned. I think in order for you to argue that it's an unapportioned, let's put it this way, this is how I'm going to argue. In order for there to be no apportionment, I think that the residual that you are arguing about, the condition like in this case Cripps, or if somebody has a knee injury and then unfortunately it doesn't work out, they have to have an amputation. Those are the kind of conditions where you're going to be looking and saying this is the result of the industrial injury, it's directly caused by the injury, you're not going to get apportionment even if there's pre-existing degenerative changes in the knee in that circumstance, or as we have here, an apportioned carpal tunnel condition. But if it's multiple causes, or if it's pre-existing and then aggravated by the industrial injury, and by that I mean pre-existing pathology, not just a pre-existing potential condition, because that's kind of what you have with the carpal tunnel.
Right.
I think apportionment is going to be more problematic or less problematic for us.
And as is key with all these cases, you have to look at the underlying facts. So the AME in this case found that Ms. Haikita's permanent total disability was due entirely to the effects of the CRPS that she developed as a result of the failed carpal tunnel surgery. And the court later in analyzing, they say, under the changes wrought by the 2004 amendments, referring to the apportionment statutes, the disability arising from petitioner's carpal tunnel syndrome was apportionable between industrial and non-industrial causes. So they're not saying that there can't be apportionment, and they even say, with respect to the carpal tunnel syndrome, that is apportionable under 4663. But they go on to say, however, Ms. Haikita's permanent total disability was not caused by her carpal tunnel condition, but by the CRIPS resulting from the medical treatment that her employer provide. And they say, the issue is whether an employer is responsible for both the medical treatment and any disability arising directly from unsuccessful medical intervention without apportionment, and we conclude that she is. That is, that she's entitled to the award of disability without apportionment. So let's change the facts a little bit. Let's say that the doctor opined, same injury, carpal tunnel, same surgery with the poor result with the CRIPS, but the doctor opines that her total disability is 50% due to the CRIPS and 50% due to the carpal tunnel surgery, and then that carpal tunnel surgery is partially, or the carpal tunnel syndrome, excuse me, and that carpal tunnel syndrome is partially industrial, partially non-industrial. Do you think that the same holding applies here, that they get the award of total disability without apportionment, or do you think the fact that the doctor said that the total disability is not entirely due to that CRIPS resulting from the surgery will allow a defendant to get apportionment?
I think under that scenario, you get all of the CRIPS, so you get 50%, and you get 90% of the carpal tunnel, and you end up combining them. The real argument you'll end up with then is the 4662A. Do you have a total loss of use or a functional loss of use of both upper extremities? One of the arguments made in this case, there's also a vocational counselor that says that the applicant was totally disabled, although I would even argue that I would challenge payment of that vocational counselor because you already have a medical evidence that says they're totally disabled, that they can't work because of the CRIPS. But that's, you have other ways of establishing the arguments. But I think in that setting where the disability is not total, what they say is you get all the disability related to the effects of the surgery. Doesn't mean you get all the disability in the case. You don't apportion to the disability for that, but the other apportionment certainly is going to hold up.
Yeah.
So another circumstance, you have somebody who has a knee injury, has surgery, develops thrombophlebitis in the lower extremity as a result of the post-surgical issue. The doctor opines that the thrombophlebitis is caused 50% by the pre-existing vascular insufficiency in the leg and 50% by the surgery. Do you get apportionment in that circumstance?
I mean, applying your logic from the last example, yes, you would.
Okay, well, that must be the right answer then.
Well, yes, of course. Yeah, I think then if I was confronted with that case, I would want to go back and push back on the doctor and find out if what the person had was a risk factor for developing the I'm not going to say it right.
Thrombophlebitis.
Yes, that. Whether they had a risk factor for developing that condition. And if the doctor said yes to that, I would attempt to distinguish between a risk factor, which is not necessarily a causative factor. But I've had similar situations where somebody has a surgery and they're stationary, sedentary for some period of time. They develop a clot, have a stroke, and have all these complications from the stroke, and but also have a history of smoking and hypertension and all those other things. I think I could make the argument that Haikita would give me the disability resulting from the stroke and all those complications without apportionment, but I'm not sure that Haikita really extends to that situation. Again, I think if you look here, the court talks about the disability being directly caused by the results of the surgery and the fact that the AME said that the permanent total disability was solely due to the effects of the CRIPS. I think those are very important factors that led to the court reaching the conclusion that it did.
Okay, so change my scenario even a little bit further. The applicant has knee surgery, develops thrombophlebitis, throws an embolus, which ends up resulting in a pneumothorax. Is the pneumothorax apportionable?
Under those circumstances, no, I don't think it is. unless the doctor is going to opine that there was some pre-existing causative factor that led to both of those conditions. I think, the further down you get with the kind of the bad luck that they're having these poor results.
Yeah, I think the embolus would probably not be apportionable. I would agree, because it's a separate condition. It's directly a result of the injury, and even though the phlebitis or the pre-existing vascular condition may have contributed to it, the actual embolus then becomes a separate condition. It's pretty hard to have pre-existing condition. I mean, you can have other factors in the lung, like obstructive lung disease, but if you have an embolus, it does its own damage, and you can identify the damage caused by the embolus.
Does this case change anything, Jake, for your clients as far as kind of their risk analysis when they're looking at a surgery that's going to be provided on an industrial basis and the things that may flow from that, or have they already been thinking about kind of the horrible list of what ifs that could happen from a surgery and planning that in their reserves and things like that?
The reality is, for cases like this, the compensable consequence, this is an additional factor to consider because of the potential additional financial considerations. It's rare you're going to get to 100%, an unapportioned 100% in these circumstances. So from that standpoint, it's not necessarily the thing everybody has their eyes on, but the real consequence for most of these cases is the additional medical care. I mean, the medical care for the Crips is probably now, hundreds of thousands of dollars. The medical care for the carpal tunnel would have been, 10 or 15,000 over the applicant's lifetime. So the medical care is ordinarily what you would look at and say that's the big concern when you're looking at doing additional surgery. So I'm not certain that this has a big impact in terms of decision making for how you handle cases, although it may be a factor when I talk to my clients in terms of, are we going to try and settle this case before surgery? Because the consequences of misadventure at surgery or having things go poorly at surgery can be greater than they were before this case existed. But I'm not certain it adds that much exposure in any case that Art Johnson doesn't have, where he's going to argue that every compensable consequence is subject to Hikita. It's not. It's only those ones which involve medical care, because this is specifically identified as related to medical care.
There is an interesting comment the court makes that I can see how folks would want to take this case and extend it quite far. It says, there's no question that Costco was required to provide the medical treatment to resolve the problem, that is the carpal tunnel syndrome, without apportionment. The surgery went badly, leaving appellant with a far more disabling condition, Crips, that will never be alleviated. California workers' compensation law relieves Costco of its liability for any negligence in the provision of the medical treatment that led to her Crips. It does not relieve Costco of the obligation to compensate petitioner for this disability without apportionment. Now again, I think they reached that conclusion because that was the medical opinion that was there, that said that the total disability was due 100% to the Crips. But I can see how someone's going to take a case where there is a consequence of a surgery and there is a medical opinion giving apportionment to that and look at this language and say, no, you employer, you defendant have to pay my client the resulting disability without apportionment, regardless of what the doctor says.
Is that only if there's malpractice?
Well, that's a whole separate issue.
I think with that we can probably stop and see if there are any other questions.
Given the recent board decision that says if the applicant goes out and procures a treatment on their own and is denied by UR, do you think that would have any impact on the Nikita application? So not that carpal tunnel surgery has been denied by UR, and this Nikita had self-procured that outside of the system. Would that have effect?
So Joe's talking about the Belinda Go case, correct? Right, where there was, I'm not, if I get the facts wrong, apologies, but as I understand it, there was treatment that was denied through the utilization review and independent medical review process. That treatment was obtained on a self-procured basis, and then the question for the court was whether the injured worker was entitled to temporary disability or disability benefits as a result of that surgery, and there was also an opinion of the case from the evaluator that retroactively said that surgery was in fact reasonable, and the court said yes, the worker was entitled to disability benefits as a result of the surgery, even though the surgery was procured on a non-industrial basis. If you apply the logic there, You know, on the one hand, one of the things the court here in Haikita latched onto was the fact that the employer had the obligation to provide the medical treatment without apportionment, and that it was provided on an industrial basis. So I could certainly see the argument that would not extend Haikita to those facts, where if you self-procured treatment, you would not be entitled to the disability or the lack of apportionment as discussed here. But I don't know. I can see the other side too, how that could be extended, especially if there's a medical opinion after the fact, like there was in Go, that the surgery that was denied by UR was ultimately opined to be reasonable by the evaluator in that case.
Since I'm not going to accept the Go decision, because I think that's an aberrant decision that ultimately is going to be challenged again and again. Because what it does now is anytime UR is denied, the encouragement is for the applicant attorney to go out and get their own, if it's surgery, just go out and get the surgery. Now, it may not be paid for, but if you've got group health or something, you get the surgery, then you go back and argue I'm entitled to the TD and whatever the PD is associated with it. So I can see that that's an issue which may be addressed legislatively, because I'm not certain that that's an intended consequence. I think under the rationale of this case, however, where it says that the medical treatment that the employer is required to provide in an unapportioned fashion, if it's medical treatment that the employer is not legally required, at least the criteria under this case as it's set out is clearly not met. In fact, I'm not even sure that the disability is going to end up being related to the injury on the basis that the treatment wasn't to cure relief from the effects of the injury, because that's basically UR's a final determination on that issue. So we'll have to see.
All right. Thank you for your attention.
Thanks for the question, Jim.
Okay, we'll take 15 minutes and then we'll start with the final panel.